Pakistan. So if Baloch disappearances cases are coming to the Supreme Court, I won't say that it's because of that, but that could be a factor that there is no Baloch sitting on the bench. So there is no sympathy really, I mean, as compared to the cases of the Islamists who have disappeared, and the Supreme Court would appear to be more willing to take up those cases, or for that matter, the high courts. So we move on, and let's try to restrict ourselves to very relevant comments or questions, so that we can finish each and every country's presentation and session within 15 minutes. Now we move on to Nepal, for which we have Govind Sharma with us, and Govind is going to talk about disappearances and torture issues in Nepal. Thank you.
Thank you, Asad. I think the fundamental question is whether the criminal justice system is adequate enough to address this issue or not in South Asia. And I'll basically talk about Nepal, whether Nepali criminal justice system is competent enough or adequately infrastructure or equipped to deal with these cases. When talking about disappearances and torture, one of the problems that we've been facing in Nepal is these two crimes are not crime under Nepali law. I mean, people may get surprised, disappearances and torture are not crime. Yes, we do have a law on torture which defines torture but does not criminalize it. And interestingly, torture is crime under Constitution. The Constitution says that torture is a crime, and people will be punished, will be involved in torturing people according to the law. There is a language in the Constitution that according to the law, but there is no law which defines torture and provides an institution to investigate when torture occurs, and also provides jurisdiction to the court, which court will be responsible to adjudicate that particular crime, and also the penalties, what kind of sanctions will be there. So torture is not crime at all, despite the fact that it is crime under Constitution. And the other fact is that Nepal ratified Torture Convention, CAT, in May 14, 1991. But we haven't been able to criminalize it. We have a law which empowers the district court to compensate victim if somebody fights a civil suit in the district court. But there are also problems. There are two problems. One, the ceiling is 1 lakh Nepali rupees, which is about 60,000 Indian rupees, or 1,000 US dollar maximum compensation for the victim. There is a ceiling which is very bad. The other thing is the definition of the torture in the Torture Compensation Act is very, very problematic, because it has to occur within the police custody. And then there is a language in the Torture Compensation Act is that if some official, public official, especially police, investigate, it says even investigating authority tortures a person in order to extract the information in relation to the crime. So it is particularly confined in a crime to extract the information, uses the force, torturing him or her. So it excludes the wider range, wider definition of the torture as stipulated in the Torture Convention at international law. So that's one bigger issue. Because of this, we try to Nepali lawyers try to find a solution on this, but there was no solution. My colleagues sitting here are who went to the different district police office and tried to file the FIR. When there was an absence of law, police could not register this FIR and act on it. That's why a writ petition was filed in the Supreme Court, saying that Nepal is a party to the Torture Convention, and torture is not crime under Nepali law. As a PIL, it was brought to the Supreme Court, and Supreme Court said that Nepal requires to criminalize torture and bring the perpetrator to the justice. That's why it issued a directive order to the government of Nepal to criminalize torture. However, it hasn't been implemented yet, and still torture is not crime. That's why the Torture Compensation Act is not effective. And one example I would like to share here is, what should we do when torture is not crime? That's why we try to, explore other avenues. For example, universal jurisdiction. The universal jurisdiction, one colonel of Nepali army has been arrested by the British police and now being prosecuted in UK under universal jurisdiction. There were two basic arguments in that case. Trial will be in the September 4th in UK. This huge case, a big debate in Nepal now, about torturing in Nepal by a Nepali, army officials to Nepali citizen arrested in UK, and there is an issue of sovereignty and all this kind of issue. But there are two issues. One, whether Nepal is capable enough to deal with torture. The other one is, whether there is a willpower with the Nepali state to deal with the torture, because they significantly failed to establish that as torture was not crime, it doesn't have the capacity. The other one is political will is not there. That's why the prosecution is going on there. The second issue I'll come on disappearances has the same kind of fate. Disappearances were systematically practiced during the conflict. I mean, we did have some cases disappearances before 1990, before the first Jana Andolan. We had disappearances, but there were not many. But after 1996, when the Maoists waged the People's War, the disappearances were systematically practiced especially against the Maoists, after the deployment of Nepal army to counter the insurgency. So there are, as we discussed yesterday, there are more than 1,000 cases of unresolved disappearances in Nepal, but we don't have the law. So we brought a number of habeas corpus cases in the Supreme Court. As I said yesterday, more than 1,000 cases of habeas corpus were quashed by the Supreme Court, saying that when the person is not in the custody, we cannot examine the legality of the detention. But later on, Supreme Court formed a high-level judicial commission headed by Justice Verma Committee, and I was also member of that judicial commission. And that commission carried out investigation of all the cases of disappearances, 84 different cases of the disappearances, and produced a report to the Supreme Court. And then Supreme Court laid down a very comprehensive judgment on disappearances. It said 4 different things. First, criminalize disappearances in Nepal. It's not crime, but criminalize with retroactive effect, as it is a continuous crime. Second, it said that there has to be an independent commission on disappearances who would investigate the cases of disappearances occurred during the conflict. Third, it said the victims should be provided reparation, not only the compensation but also the whole concept of reparation. And fourth, it said that the people who suffered so far and came to the court, it took long time, 7 years, they fought these cases. They should get some interim relief. So the notion of interim relief was introduced in Nepal. Supreme Court asked the government to provide 1 lakh Nepali rupees, 150,000 Nepali rupees, and 2,000 Nepali rupees, according to the people who suffered from that particular incident. The decision is there, but decision has not been implemented so far. So. And so in this case also Supreme Court said that prosecute those people who found extrajudicially executed. Yeah, 3 minutes. Thanks. I'll finish in 3 minutes. And the Supreme Court also dealt with the cases of extrajudicial execution, not only disappearances in this case. Supreme Court said that those who we found out, Judicial Commission found they were killed by the security personnel. We exhumed the dead body. We did the exhumation work as well. Then the Supreme Court said that prosecute this particular officer under this homicide chapter of the law. So it said that all the cases of the conflict which were political crime, the comprehensive peace agreement we had, which has some sort of notion of amnesty, not fully amnesty, but some sort of kind of, if people were prosecuted because of their political belief, these cases could be withdrawn from the court. But they used this provision in order to not to prosecute all these people. But court said that no, you need to prosecute if there is a very clear violation of the criminal law. That's what the court said. Now the question, the fundamental question I raised about, whether the criminal justice system is able to deal with these torture and disappearances or not in the region, especially in Southeast Asia, I say no. The Nepal's criminal justice system is on the verge of collapse. The police is highly corrupt, and there is a huge torture is practiced, systematically. Even to this date, it's systematically practiced because they don't believe in the scientific investigation system, and highly corrupt and politicized police we have. And judiciary is the kind of same, they don't want to deal with these issues where there is a politics or something, communal kind of thing. So I agree with Asad, who was raising an issue of the regional mechanism. Probably we need to think about not only for the cross-country prisoners, maybe what we need to have a regional system, maybe regional human rights system within the SARC. Let's try to explore within the SARC, because ASEAN have already started, they have this human rights commission now, and they probably form a court. And Africa has a system, Inter-American system is there, European system is there, but we don't have Asian system of human rights. Maybe try to form a SARC level human rights commission or court kind of thing, where we could deal with all these issues, because these issues are common. Thank you.